Welcome, everybody. Again, welcome. And welcome to those who were able to join us because of our technology issues the last session. I'm so sorry that it happens, but that is just the world we're in. So the good news is there's a lot more people that got to join us today. So I think that's pretty exciting. So thank you everyone for joining in. It's a wonderful day out there. As they say, Mr. Rogers says, it's a beautiful day in the neighborhood and an even better day tomorrow. In fact, I'm actually going to go hit some golf balls at them. So I'm going to find this quite exciting and challenging. Challenging is probably the word. So thank you everyone for joining in. It is our Thursday live edition, our 16th edition. And
there we go.
We're good?
Yes.
They're making me nervous, Adam. Like, oh my God. This is called a test. Is it a test? All right. So we want to get rolling because I believe there's going to be lots of questions. And I know that there's lots of great information that we want to cover off with Adam, and we'll formally introduce him. So a couple of quick housekeeping items. Last month, we did have a prize winner for someone who wanted to enter an answer to a question that we had. And I believe Tracy's in the audience today. So Tracy, you were the winner of last month's gift certificate for the Cavalier, the Sheraton Cavalier. So hopefully you can get out and enjoy it on this beautiful day. We also will be taping this session. So it will be there along with our other webinars, our cliffhangers, and our videos. They'll be on our website and they'll be on our corporate Facebook. So if you don't have a chance to finish the session today, if you know there's someone that would value from the information that we're going to share, please share it. We would love it if you can share it to those who will be able to learn from what we're going to talk about today. We are going to give another prize away for today. And so what we're going to do is there's going to be lots of information. I think the easiest way to do this is a takeaway. I want you to send to us one takeaway that you got from our conversation with Adam today. And I'm really excited to be able to tell you that we're going to provide for the audience 2 passes. We're going to give away 2 passes to the Breaking Barriers conference that's coming up on May 7th. And it's with our partner, preferred partner, Bridges Health. It's a company that's in Saskatchewan, but they do work across North America. They have a very, very strong reputation when it comes to psychological and mental well-being. And they've got some great speakers out. It's morning session. It's 8:30 to 12. It's going to be done in workshops that you can join in on the ones that you want to. There's going to be some fabulous speakers. Joe Roberts will be talking about resiliency, which is top of mind when we talk about mental health. And there's going to be other special guests, Alex Fallon, great friend and client of ours, Leon and Kyle from Bridges will be there presenting as well. So I believe that we're going to very easily be able to give those tickets away. So again, one takeaway from today's session, send it to us to our email address and we will put your name in for a draw to win. Oh, and I should mention too, the funds that they're going to raise are going to the Possibilities Recovery Center. So it's the first and only Saskatchewan-based company for intensive outpatient addiction retreatment program. And again, when in my space, we talk a lot about mental well-being, it is the area that we find some struggles or challenges with is getting the treatments and the programs that can help those people get better. So really great to see that we've got now something based out of Saskatchewan. So let's get going. Again, the theme, taking care of business, and we are going to do that today. Today's session, we're going to be addressing the legal issues facing employers in 2021. And certainly what we're going to learn today, how we can carry them forward and keep them at bay. We've got today's special guest, Adam. Welcome, Adam, to our session. He is the partner of the W Law Group, and he's head of the litigation department. He's got a very impressive resume. He is, and I should mention the W Law Group is a preferred partner of ours as well. So I know, Adam, you and I talked and we had mentioned that if there was any questions that people have following, you'd be more than happy to share and consult with them on a short telephone call if they were to call.
Absolutely.
Perfect. Perfect. Adam has represented both the employers and the employees in the unionized as well non-unionized workplaces regarding claims of wrongful dismissal, discriminatory action, and other employment-related matters that fall under the Saskatchewan Employment Act, the Canada Labour Code, and the Saskatchewan Human Rights Code. He's extensively in the area of labor and employment law on a wide range of employment topics. And when he's not hard at work, he's busy volunteering his time and his expertise. So he appears on various boards, a couple of Saskatchewan Labor Relations Board, the Highway Traffic Board, the Canadian Human Rights Tribunal, the Specific Claims Tribunal, the Automobile Injury Appeal Commission, oh my gosh, and the University of Saskatchewan Academic Dishonesty Hearing Boards, many that I haven't heard of. So that sounds like you're going to be very, very busy. And let's add to that, he's got a family of 3 young children. So that probably keeps you more than doubly busy.
It does.
So, welcome, Adam. Welcome, Adam. So again, today we want to really get into that employment law conversation. And for lack of better words, I want to maybe say that, and perhaps due to COVID, the employment law is maybe exploding right now. And there's lots of conversations and questions and concerns that our employers and our clients are having out there. So our focus today will be looking at not just the issues that relate to COVID, but perhaps what COVID's done to maybe escalate and bring them to the forefront, and what we need to be now really thinking about so that we don't get caught, for lack of better words, with our pants down. It's teaching us and maybe reminding us that we need to be doing good business before things happen. So to be much more proactive. So I'm going to start, I think, Adam, what we'll do is I'll start and I'm going to say, let's just kind of go back to maybe the pandemic. Let's go back to the beginning of the pandemic and kind of the things that were happening when that hit and the employers, what they were facing.
Sure. So first off, thanks, Deb, for having me. And obviously, I can only speak to the issues that I've seen. I can't obviously speak for other employment law lawyers. But back when the pandemic began, obviously, one of the things that was most top of mind for most employers was, how do I lay off someone? And at least at the outset, it was pretty chaotic because it seemed like legislation was changing every few weeks. Initially, there was no provisions which specifically dealt with layoff during a pandemic. Then we had amendments to the Saskatchewan Employment Act, which instituted public health emergency leave. Then we had amendments to the regulations. So at the end of the day, the way to lay off an employee during the pandemic is the employment standards regulations allow you to indefinitely lay off an employee during a public emergency. But once that public emergency has ended, employers have a grace period of 2 weeks to return employees to work. And that's remained essentially stable since May of last year. So that's what the regulations provide, that you can lay off an employee for an indefinite period of time during a public emergency, as long as once the emergency ends, you can return them within 2 weeks. But in doing so, you still have to be really careful with how you deal with that. And the biggest things are, even if the regulations allow for a layoff, you have to keep in mind human rights issues. You have to keep in mind whether there's a contract of employment which restricts that. You got to keep in mind collective bargaining issues. So that you also got to keep in mind common law entitlements. So I appreciate that seems like there's a lot of questions there. But at the end of the day, the regulations allow for a layoff, but you still have to be careful. And I know lawyers love to use the term, you got to deal with it on a case-by-case basis, which I assume everybody else hates. But it is true. It's with layoffs, even though the regulations allow for a termination or a layoff for an indefinite period of time, you still have to be really careful with how you do it.
So is there, if you had to, and I understand, and I know that I don't want to put you into, because it is the very gray area, but would there be one effective way that people could have been handling a layoff?
So the biggest thing is to be proactive in how you dealt with that. With the layoffs, for the most part, most employers can utilize the regulations. And if they were in a situation where they had to lay off someone over the last year, the public health emergency or the regulations to employment standards allow for a layoff. They allow for a layoff for an indefinite period of time. There's no restrictions on why you lay off an individual. So at least under the regulations, if employers want to be proactive, they can lay off an employee. They got to give them You want to have it in writing, so it's properly documented. But at the end of the day, you can lay off an employee as long as at the end of the public emergency period, you bring them back within 2 weeks. So that for the most part, at least at the outset of the pandemic, that's what most employers that I dealt with were facing. And then it slowly moved to, well, how do I bring them back?
And I know that, and this is where we talked a lot, like in terms of the legal to the benefit side, because one of the things that we saw a lot was the sensitivity of the other side, the employment side, because people forgot when they come to us, and then it came to benefits and laying off. And we already had our kind of our standard procedure, but all that changed as well. Like everything changed on the benefit side, and it changed like weekly. So I know that's probably the part that really frustrated people, is that we never really had, and you never had an answer at that point in time, because it was a revolving conversation.
Yeah.
And
well, it was, at least at the outset of the pandemic, that was certainly the case. I remember, because and lots of employment law lawyers would provide advice on Monday, and by Wednesday there was a new enactment. So we provide new advice, and then that changed again. So it was certainly for a little while, it was chaotic. But at the end of the day, the amendments were made. And
yeah, I agree. And even now we're dealing in the permanent layoffs, and still there's those questions about what we can do on extending benefits and things like that. So it goes back to the conversation, what are you doing on the other side of that? Because you need to deal with that before you can deal with us. So it's a very collaborative relationship is what it becomes. So for employers that did do the layoffs, how did they bring them back? Was there a certain way and procedure in how they bring them back?
So no, not really. Like as long as you provided the opportunity to return to employment, you wanted to document it. I think the biggest issue that I saw with a lot of employers was employees who didn't want to return, and how to deal with that type of a scenario. And a lot of it came down to, why didn't that employee want to come back? And depends on when over the last year happened. There were certain employees who were laid off in April and May of last year, who by October had found different employment and simply didn't want to return. And for those employees, it would usually be considered resignation, and you need to document that properly. But if they didn't want to return, so be it. The bigger issue for a lot of employers was employees who didn't want to return because of COVID, or because they deemed the workplace to be a dangerous workplace. And it was those situations where employers had to be really careful as to what they did. And a lot of it came down to morale too. It's never a good situation to force an employee back to work. You don't know what impact does that have on the employment relationship long term. Is it in the best interest of a company to force an employee to come back? And there are a number of situations where employees didn't want to come back. And I dealt with employers who said, you know what, so be it. You document it properly, and maybe that leave continues longer until that employee is comfortable returning. And in part, that helps save the employment relationship. For other employers, that wasn't an option. It was a situation where we need that employee back. So in those particular scenarios, the Saskatchewan Employment Act provides employers the ability, or it provides workers with the right to refuse dangerous work. So if an employee is saying, I'm refusing to come back, I believe the workplace is dangerous, there's a couple of things employers could do. They can, first off, conduct their own investigation to see if they can take any steps to satisfy the concerns of the employee. And if not, if you're still at a standstill after that, then the employee or the employer can request an occupational health and safety officer to investigate the matter. So an occupational health and safety officer will come into the workplace, make a determination whether it is safe or unsafe. And if the officer determines that the workplace is safe, the employee no longer has the option to refuse to work. And if they subsequently refuse to come back, then the employer can look at discipline or eventually lead into termination.
You know, and it's interesting because you're right. I mean, yes, you need them back, and yet you don't want that relation to be strained. And in today's space now, what we're dealing with is we've got this real big conversation going on about building a wellness culture. So it's not really going to work if you're forcing people and you're trying to develop this place that's a safe haven, and that we're there and we care for you when we're trying to work on this wellness culture. So I imagine that becomes quite difficult. we do have a question, and I want to remind the audience that we're very open to the questions that come during our session, and we will allow as well those wanted to just maybe send us an email after, and then we can certainly respond back to you. So we've got a question. Hi, Neve. How you doing? So he's got two questions. Can employers make vaccinations mandatory to return to the workplace, especially if the work cannot be done remotely?
So that is a minefield. Here's what I can tell you, that there's, at this point in time, there's no case law that the courts have not ruled on whether or not you can mandate vaccines. And if you look into it, there's a lot of different lawyers out there providing their own opinions on what they anticipate the law is going to be. Here's my thoughts on this, and I do preface it by the fact that the courts have not made a determination. The Saskatchewan Employment Act obligates employers to ensure the health, safety, and welfare of their employees. And that includes ensuring their safety and welfare during a pandemic. So the question is, well, does that extend to requiring employees to get vaccinated? My personal thoughts on it are potentially, but I think only in very limited situations. And there's a number of factors which you would need to consider. One is, but by the time that everybody in Saskatchewan has had an opportunity to get a vaccine, does having an unvaccinated person in the workplace still pose a risk to the other vaccinated employees? Is the public emergency period over by that period of time? Is COVID still prevalent in the community? If our numbers, by the time everybody's vaccinated or had an opportunity to be vaccinated, if the numbers are so low that the public emergency period is over, is it still going to be considered reasonable for employers to require vaccinated employees? Or are there less intrusive measures such as social distancing, wearing masks, working from home, that could achieve the same results? Are there other human rights issues? Are there contractual issues? Does requiring vaccines conflict with employment contracts or collective agreements? And then you look at the nature of the business. Are there high-risk individuals? I think for the most part, the answer is going to be no for employers. I think there will be certain scenarios, for instance, if you look at a small care home, for example, where social distancing or other less intrusive measures are not possible. If you're dealing with seniors or other vulnerable people who couldn't get the vaccine themselves due to medical reasons. Yeah. In those situations, bringing an unvaccinated person into the workplace, there may be an argument there that the vaccination is necessary to protect the health and safety and welfare of employees. I think in most workplaces, it's going to be a much more difficult argument. And again, there's no case law on that right now. So for the most part, those are just my thoughts. And it may be that by the time we get there, there's legislative direction on it. It may be that the Saskatchewan government has certainly enacted a number of measures to address these types of concerns, as we saw with layoffs. It may be something that there's legislative direction with respect to vaccinations. But there's so many factors there that right now, not knowing the prevalence of COVID-19 in the community by the time that question would arise, I think it's going to be limited, just because requiring a medical procedure of an employee is a fairly invasive measure. And if there's less intrusive measures that are just as effective, I think it's going to be limited to very limited work environments where that would be justified.
And I wonder too, and because there's always this, is remote. Yes, we can work remote, but is an effective way to be working. And there's always that push and pull about, sure, we can all stay at home and work, but are we able to effectively work? Some can, some can't. Depends on the jobs, the roles. But maybe that plays into this, because if someone is not wanting to return and wants to remain remote, is that the right answer on an employer level?
Yeah, and that's it. That there's so many issues there, and how far into the future do we look then? If everybody's had an opportunity to get vaccinated, let's say by summer, Okay, can you require vaccinations or vaccinate employees by August? What about next January when you're hiring new employees? At what point is the prevalence of COVID-19 diminished enough in our society or in our community that it's no longer poses that same risk to the work environment? And in the meantime, is it possible to accommodate? And there's going to be human rights issues on this. There are undoubtedly going to be individuals who refuse vaccinations for religious reasons or other reasons which would fall under human rights legislation. Well, you're going to have to accommodate those employees in any event, and it's up to the point of undue hardship. Well, are those less intrusive measures possible right now? And if you can impose those measures without it presenting an undue hardship on the employer, I think it's going to be tough to justify.
Yeah, as you said before, a landmine.
Yeah.
So you talked about, some of the considerations in terms of what we can do and how we can handle that. So we talked about, we'll start with severance obligations.
Yeah. So like one of the biggest things I've seen since the start of the pandemic, a lot of it was layoffs. Now, as the situation's evolved and most employers, not everybody, but have brought back the employees that they intend to bring back, there are still a number of employers with employees who have not returned, who they do not intend to return. And it's dealing with those employees. And if you don't intend to bring them back within the 2 weeks following the end of the public emergency, which is what your requirements are as an employer, what do you do? And it's how to be proactive in those scenarios before you're forced to do it. If you know you're not going to bring an employee back, if you wait till the end of the pandemic, you have no option. You're forced to, and it's trying to be proactive in those scenarios. And like you said, one of the biggest things, at least the preliminary measure, is figuring out that employee's severance obligations. So as a starting point on that, I got to look at whether there's an employment contract in place, because in the employment contract or collective bargaining agreement, but it may dictate what their severance entitlement is. You got to look at whether there's human rights issues for terminating that employee. But if there's no written contract and there's no human rights issues, then if you're considering not bringing this employee back, you got to at least look at what their entitlement is. And unfortunately, this is where I've seen a lot of employers run into big issues. And the biggest thing is knowing the difference between statutory entitlements and common law entitlements. And under the Saskatchewan Employment Act, it sets out the minimum statutory entitlements. So for an employee who's been there more than 13 weeks but less than a year, they get 1 week. More than 1 year but less than 3, they get 2 weeks, etc., all the way up to anybody who's been there more than 10 years, they get 8 weeks. And unfortunately, I've seen a number of situations where employers have tried to be proactive and they've reached out to employment standards and been informed that for a 10-year employee, all you need to do is provide the minimum 8 weeks. So they go ahead and do that. And they think that 8 weeks is good. But the problem is that ignores someone's common law entitlement, which can create significant liabilities for the employer. So when I'm saying common law entitlement, it's looking at things like the age of the employee, the length of service, their position, the availability of similar employment, their training, etc. And I don't have time to provide an exhaustive list. But in terms of the contrast, you may have an 8-year employee, let's say, who under Saskatchewan Employment Act is entitled to 6 weeks statutory notice. Their common law entitlement might be 6 months. Or you may have a 30-year employee who's only entitled to 8 weeks statutory notice, but whose common law entitlement is 18 months. And that's the biggest thing at the outset, is figuring out what that person's potential entitlement is before termination, not afterwards. And I can tell you, I've seen a number of situations where employers come to me and they say, well, look, we terminated this employee, we provided them with a minimum statutory notice like we were obligated to do, and now we've got a demand letter saying, pay me 6 months or 8 months. And if you don't understand what the entitlement is in advance, you can run into significant problems. So that's kind of the biggest preliminary measure to take prior to laying off or terminating that employee, and prior to terminating any employee for that matter, but especially the ones who are off right now. That's the biggest thing at the outset that you can do is figure out what the obligations are. Then you can look into how to be proactive.
And you're right, because I think quite often people kind of see one side of this formula and not the other side of the formula. So they think of the severance package and they're just missing the biggest risk, the liability on the other side. So yeah. I've got a couple more questions.
Sure.
And you let me know too, Adam, if you prefer to just hold them off to the end. So, but Hanif is asking another question. Thank you, Hanif. I want to actually mention, and it's a shout out to Hanif. Hanif is with Express Employment, and he is our other preferred partner. So, I mean, it's really quite cool that we've got 3 of them all together in one session. So Hanif's got a question. If someone gets COVID in the workplace, if they don't get vaccinated, are they entitled to WCB or short-term disability benefits?
So potentially, and it comes down to a couple different things. One, whether there's an isolated breakout at the place of employment. It's one of those things that the workers' compensation is going to look at, and it's whether there's confirmed exposure of COVID-19 in the workplace, whether the employment involves sufficient exposure, and whether the nature of that employment creates a high risk of exposure. It's conditions WCB are going to look at to determine whether or not that there's sufficient grounds for a WCB claim. So I anticipate that it's an evolving process. It's by no means is it something that, well, if someone gets COVID and they're at work, that it's automatically going to be classified as a WCB claim. But infections will be deemed to be work-related when they contract it as a direct result of their employment, if those conditions are met.
Okay, and thanks, Dustin, because he made a comment back, because he just made a comment that he had looked into it, and he said that they are.
Yeah.
So, but if it's not directly related to the business, if it's not directly related to the business, workers' compensation account, but yes, they will get workers' compensation benefits. Is that correct?
So the COVID has to be a direct result of their employment, and which means there has to be confirmed exposure in the workplace.
Make that. Okay. Yeah. So if we want to get into being the proactive, what are some ways in which we can now reduce that liability? How do we go about doing that?
Sure. So if you have an employee who you know what their severance entitlement is, you know that then if you wait right now, so if you have, let's say, a 15-year employee, and if you wait and you know you're not going to bring them back, if you wait to the end of the pandemic, you're going to have no choice. Now is kind of the opportunity to try and address that. And there's a few different ways to do it. But primarily it involves negotiation with that employee. And that employee may be in a situation right now where there's a whole lot up in the air. The employee may not know when their return date is. And right now their employment status is in limbo. And because of that, there's an opportunity for both sides to provide some certainty to the situation. And it may be a negotiated payout. It may be an incentive for resignation. You got to deal with it on a case-by-case basis, which I appreciate people likely hate that term. But it is one of those things. If you wait right now, if you wait to the end of the public emergency, you have no choice. You lose all your leverage as an employer in negotiations, because if there's an end date, that employee knows, well, I'm either being brought back on August 1st or whatever that date is, or I'm being paid out my entitlements. If you do it in advance and you reach out to that employee, and there's a bunch of different ways to do it, you can address it earlier, you can provide certainty to both parties, and there's a better opportunity for a negotiated settlement at that stage. So that's kind of how to be proactive with employers who are already off. The biggest thing then is how do you avoid being in that situation in the future? And it's how do you be proactive so you don't get caught in this type of situation?
Yeah, exactly. Well, as we mentioned, I mean, the paycheck goes from here, right? The commitment goes from here to here. So we'd rather being the lesser of than the more of on that. And I know when it relates to severance, and a comment to the audience, because one of the things that, again, you have to be really mindful for is how that relates to the benefit side. Because a lot of times what will happen is they will go about doing this agreement. It goes into place. We don't hear about it. And part of that sometimes ends up being that people will put the benefits in there and they'll say, well, you know what, for that period, that extended period post working, we're going to extend benefits for a year. Well, in the insurance world, that's not necessarily possible, right? And so it's really, we've come across where they've done an extension of benefits and they're on for disability benefits, health and dental. Perhaps some of them can be extended on the health and dental. It's usually the place that we can play in a little bit, but definitely not on the disability side and on the life side. So anytime you're going through those severance conversations and they're out there, you need to bring that conversation back to your advisor. We would be more than happy to share in what our experience has been, what you need to be doing, again, to be more proactive on that, because that probably be double trouble if now something happens to that employee and they end up, or post-employee, end up on disability, and now they feel they've got a claim and they don't. So and we're going to see a bit more of that. So we had a lot of action, of course, on the layoff side of things. We still do, because now we've moved into the permanent layoffs. And now I believe, to your conversation today, we're going to start to see more of that conversation as it relates to the severance side of things as well. So again, the two go hand in hand. If that happens, you need to make the call back to the benefit side of things and make sure that you got your P's and Q's in order as well. So Dustin I'm not sure, Dustin, you made a comment about outbreak. As in a question, if there's an outbreak in the organization. Maybe I'll wait and you can answer to that. And Pat's got a really good question. Hi, Pat. Pat's our HR manager. She ropes us and makes us be good in the office. So Pat, you've got a question. Can you speak to privacy of vaccinated and non-vaccinated employees and information in the workplace? And that's a great, because I was going to actually ask that question. So that's a great question, Pat.
So yeah. The health status and medical information of an employee is deeply personal, and it's typically confidential. So it kind of ties into whether or not only whether or not can you mandate vaccinations, can you even ask an employee if they've been vaccinated? And it has to be reasonably necessary for a legitimate purpose, and only if there are not less intrusive ways to achieve it. And it's kind of the similar analysis to whether or not you can mandate the vaccine. It's not a scenario where every employer is going to be able to ask an employee, well, have you been vaccinated? Assuming you fall into the category of employers who are able to, then there's obligations on you, an employer, how you deal with that information. Because there's statutes out there that deal with the collection, use, retention, and destruction of personal information. So it is something that if you're contemplating doing that, one, you have to have a well-documented or carefully drafted policy in place for how you request the information, but also how you deal with the information. Like I said, it's not going to apply to every employer, but the ones who are going to have an ability to request that information, you have to be really careful how you manage the information.
Mm-hmm. And would that fall in line even with the idea of sharing the fact that someone's been vaccinated? Because that's a little bit of a breach on privacy as well, right?
Absolutely. There's a whole lot of issues with what you do with that information, how you maintain the confidentiality of that information. So you're going to have to put safeguards in place. So yeah, there's a whole lot of issues there, but you do have to be very careful. It's not simply a situation that, well, if someone has the right to request it, you can just request it and so be it. It just goes in their employee file. It's medical information. It's something that you have to follow the statutory requirements with respect to collection, and destruction, retention, etc.
Good point. So going back to Dustin's question, so yes, it was about the outbreak. So what kinds of risks do employers need to be mindful of if and when they get an outbreak in the workplace?
Oh, if there's an outbreak in the workplace, you have to be incredibly careful because, as I mentioned before, you have an obligation to ensure the safety of your employees. What steps you take following that outbreak are going to be based on the individual workplace, but it's implementing whatever measures are necessary to, one, stop the spread of that. Typically, there's lots of work environments where there's the ability to close and work remotely. That's not going to be every work environment, but it's a little bit difficult to answer on a global scale because the measures which each individual employer are going to take are going to differ based on the nature of that work environment. But there are certainly risks if you don't take the necessary measures. It's if for example, if you have someone, if an employer, if there's one individual that it has COVID-19 who entered the workplace, if the employer becomes aware of that and don't take any measures to prevent the further spread of that, there's a significant potential for liability. Absolutely. And it's like, so it's a little bit difficult to provide any overarching principles beyond that. You have to be very careful to ensure that you're responsive and take whatever measures are necessary to manage that risk, keeping in mind the ongoing duty of the employer to maintain the health, safety, and welfare of the employees. So I don't know if that fully answers the question, because it is something that's kind of unique to each individual workplace.
And I'd be thinking of even from the PR perspective. Like, I mean, if this got out and if you just threw it under the carpet and maybe wash down a couple countertops and, you know, business as usual, all it needs is one conversation. And then it just goes like that. So I could see the danger in that. So, I mean, to be proactive, I mean, we've already seen that with many, many businesses. They absolutely shut down and they do a full cleanse. And then they shut down for 2 weeks.
That was one of those cases at the outset, because at the outset of the pandemic, you recall that the government was often releasing the location of the outbreaks, at least initially. So there was huge concerns amongst employers. Well, if we have an outbreak in our work environment, that from a PR standpoint, it can be devastating. Sure, but you have to always keep in mind your obligations to ensure the health and safety and welfare of your employees, and putting public relations in front of that could certainly expose you to significant risk. Yeah,
absolutely. Jackie, I'm going to come back to your question because we've got a couple of things we want to touch on. I won't forget about you, Jackie, though. I just kind of want to go forward and we talked about, you know, what's happening on the severance and the be proactive. And I guess we should go back to the conversation. How can we avoid ending up in that position again?
Sure. So the biggest thing, and I've been stressing this pre-pandemic, is get employment contracts. When I talked about before the difference between statutory notice and common law notice, for a 30-year employee, it may be difference between roughly 2 months and 18 months. If you have a properly drafted employment contract, you can have terms within the employment contract which set out an employee's entitlement, which can be in certain contracts, it can be as low as the statutory minimums. So if you have a 15-year employee, depending on the nature of their contract, their entitlement can be as low as 8 weeks, as opposed to as high as 12 or 15 months if there's no employment contract. And again, with common law entitlements, there's so many factors into how their entitlements, or what goes into determination of their entitlement. But the biggest thing from an employer standpoint is avoid that risk, avoid that unknown.
Mhm.
And if you have an employment contract, there are countless benefits to having employment contracts, and I certainly don't have time to go through them all. Determining severance is only one of those many benefits. But if you are in a situation where you have a properly drafted contract, you have you have carefully worded termination provisions, you can greatly reduce your potential exposure when you run into a situation where you have no option but to terminate an employee. And when I say greatly reduce, the difference between a properly drafted contract and no contract can be as significant as 8 weeks and 18 months. It's one of those things that it's hard to overstress the importance of employment contracts for employees, because there are significant benefits to the employer, and there's significant benefits to the employee too. And by no means am I saying or suggesting that all employment contracts should limit employees' severance entitlements to the mandated or statutory minimums. But there's a whole lot of ways to structure it in a way that avoids the potential risk that I've seen a lot of employers face over the last year, where they are in a situation where they have no ability to retain an employee and are facing severance obligations, which have the potential sometimes to cripple that business. So it is one of those things, implementing employment relationships for both new employees, which is a little bit easier to do, but also for existing employees who don't have them, which is a little bit more difficult to do, but it's certainly still possible. It just takes a little bit more work to get them in place. But having that employment agreement in place is how you avoid the uncertainty that I saw a lot of employers face over the last year.
And I can see more of the concern maybe on the existing employees, because now with businesses having to, look at how they're doing business differently and restructuring, it changes that relationship. So what you have before going in may not be necessarily what's going to be working going forward.
Well, absolutely. And like you see, there's a ton of employers who will have 15 or 20 or 25-year employees with no employment contracts. And if you're in a situation where, because of hopefully not another pandemic, but there's lots of situations arise in the course of the life of a business, which necessitate layoff or termination of employees. Well, then if you look right now at what your potential exposure is for those employees come 5 years down the road, how do you avoid that type of situation?
Mm-hmm.
And as much as there's time spent initially getting those employment contracts in place, the ability to reduce your exposure 5, 10, 15 years down the road is huge. And it can be the difference between having a profitable year and crippling your business because of the size of some of these severance payments. And obviously it depends a whole lot on the nature of your business and the size of the employer, but requiring or having to pay 18-month severance to an employee, that can have a pretty big impact on a business's bottom line.
Absolutely.
And so it's considering those things, and when looking how do we avoid situations like this in the future, it's getting the employment contracts in place, which provides that certainty, so you know what to expect when you run into a situation where you have to lay off.
Yeah. And that's why we get along well, because that's no different than in our space, because the things that we really will advise our clients on has a lot to do with what you're talking about. Because when we get into benefits, an extension of benefits for disabled employees, there's no handshake involved. It's you need to get it into writing. You need to have an end plan, because you can maybe change that end plan, but if you don't have an end plan, that end plan can go on much longer, and the liability becomes huge on that. And we see it many, many times where people don't have contracts in place on how to handle benefits for extending to disabled employees. And now you've got a claim that could last 15 years versus 2 years. Big difference. on how that's going to impact the employer. Absolutely. So again, no handshakes involved. We need to be really diligent in terms of getting things in writing, and the advice needs to come from the experts. And you do it right the first time, minimizes your issues on the ends of it, right? So excellent comments. I'm going to go back to that question, Jackie. If an employee can do their job from home, can the employee request or demand to still work from home until the pandemic is over, rather than being in the office?
Can the employee still demand to do that? Is that
Can
the
the
question?
employee request or demand?
So if it comes down to, there are a few, like, part of it is what the employment contract says. But if an employer is in a situation where they require that employee to be in the normal work environment, and they refuse, it's no different than refusing to return to work. It becomes, well, unless there's they can establish that it's a dangerous work environment for them to be in, which I talked about previously. You can do an investigation with an occupational health and safety officer to determine it's safe. If the work environment is safe, the employer, in most circumstances, will not have the ability to refuse to return to work, and cannot dictate that they get to work from home. Again, you got to be. I don't want to give any blanket statement, because there may be circumstances that would affect that, but on majority of situations, if it's a safe work environment, and you may have to go through that test. Like I said, if the employee suggests it's dangerous, you may have to get an occupational health and safety officer in to determine that it's safe. But if they do, then that employee, in most circumstances, will not have the ability to refuse to return to work in the regular work environment.
Yeah, no, good point. I had actually a couple of questions, and if anybody out in the audience has one, we've got definitely a couple of minutes left. We talked, I think there's a lot of conversation on the vaccination and how that rolls into, the ability to work, not work, and who's maybe in favor and not in favor. Do employers need to provide paid time off for people to get the COVID vaccine?
Yes. So the Saskatchewan amended the occupational health and safety regulations to allow workers paid time off to receive vaccination.
Certain amount of hours?
The minimum length of leave is 3 consecutive hours.
3.
So, however, employers may decide to provide additional time if required in the opinion of the employer, but it is paid time off at the request of the worker for obtaining a vaccination for a minimum of 3 hours. Okay. And that leave cannot result in loss of pay or other benefits.
So is there a difference in terms of the approach? You talk about, employment contracts and kind of some of the rights of, is there some differences between the obligations between a private sector company and a unionized environment?
Yeah, absolutely. So with a unionized environment, you have to look at the terms of the collective agreement and the management rights clause, which essentially is just an extra hurdle. You still need to look at all the other factors, but in addition to that, you've got to look at whether or not an employer in a unionized environment look at the collective agreement to see how that impacts the right of that employer to mandate vaccinations, to obtain, to request information about whether an employee has been vaccinated. It's more or less, it's an extra hurdle. And I don't mean that negatively, but it's one more thing you have to consider. So.
Yeah, good point. Well, I'm doing well on my questions. Is there any other questions in the audience? Adam, is there anything else that you want to add? We've gone through an awful lot of information, and I hope everybody's pens are diligently writing notes, but we can always know we can come back to you if we have any questions on it.
Yeah, I don't have anything further to add unless there are any other questions.
I think I could ask a lot of questions, but in lieu of time, we're going to maybe do a wrap up. If there's any questions that do come, please, by all means, send them our way and we'll get back to you after the event. So we really, oh my gosh, we covered off a lot of information, Adam. And I think in today's world, I think now more than ever, we realize the importance of doing things and doing it right and doing it preventatively, proactively. And I think that's kind of the biggest takeaway that I've got. So again, to the audience, if you would like to get a ticket for the Breaking Barriers Conference, that's going to be on May 7th. All you need to do is share with us one takeaway that you got from today's session. I would assume based on the questions, there's many takeaways that we had today. So I thank you for being with us, Adam, and I thank you for the audience being very active in the conversation with us as well. So it always makes it much more fun. So a couple of things as we wrap up. I do want to say thank you, Adam, so much for coming out and joining us. I think there's lots of great information. This would be a session we probably need to do again, I would say in a few months, and see what's happening. As we said at the beginning of our session, things will change quickly. And maybe by that time, there's going to be a whole new set of conversation going on. So we might be doing this again in a few months. And I think that would be great. A reminder to the audience, again, for those who want to share this information out with their colleagues and contacts that they have within their spaces. This is a taped session. It'll be on our website and our Facebook. So do we welcome you to go to that and share it out to those you might think will have some great takeaways from this event. Next session is going to be, and it's May 20th, I believe. So our next session is going to be, our theme next month is Mind Your Own Health. And with that, we've got actually some really interesting dialogue that we're going to have around disability management. Because again, we always say thanks to COVID, maybe yes, maybe no, but thanks to COVID, it's raised this conversation to a whole new level. And so we've got a case disability management consultant from Manulife. Her name is Carolee Shorney, and with a guest to join, Roger Delaki, and he's our account executive for Manulife. And they'll be talking about barriers for managing disabilities through the pandemic marathon and beyond. And again, something that we're really seeing a lot of, especially when it comes to the mental health space, there is just really a lot of uncertainty on how to go about managing these claims and the rights and the processes and the procedures that we need to be abiding by, so that it becomes a win-win for everybody, the employer, the employee, and the business community. So that will be our next month's session on May 20th. Other than that, I want to say thank you to the audience. Thank you again, Adam, for coming out to join us. And do enjoy, as I always like to talk about the weather, do enjoy this beautiful day, especially tomorrow. That's what we need to get out there, get some fresh air. It's good for the mind and soul. Thank you again. Stay healthy, stay safe, and have a wonderful rest of the day, everyone. Bye now.